Make your lordship. My lord, may I pray for listing a matter for hearing next week and subject to convenience?
Hearing you have to make application for.
Or is there is an order
No hearing.
for listing? There is an order. Paperwork is already ready, lordship.
You make an application before the registry.
Registry. Should I?
Because hearing list is already there.
Yes.
And
sir.
these hearing matters are out of that hearing list only.
So can it be for orders next week? So that
Make an application before the registry for hearing.
Please, your lordship. Lordship, I beg to mention on criminal appeal along with an IA, lordship, for bail. Already objection has been filed. May I
Okay.
pray for
Next week?
on 21, lordship?
Next week, next week.
May it please your lordship. Lordship, I beg to mention item 15 of the supplementary list. Here, your lordship, the arguing counsel is out of station.
Oh, NK Golja.
Supplementary list, your lordship, item 15.
WPC line.
Yes, WPC.
NK. Okay. You are Mr.
SK Chakma, your lordship.
S.K. Chakma. On the prayer of Mr. S.K. Chakma, learned counsel for the petitioner. Release the case after how much? 2 weeks?
Next week.
After a week. It is submitted that the counsel has been taken from the learned counsel for the other sides to make the prayer.
Deeply open.
For orders, item numbers 1 and 2.
Lordship, item 1 came up for hearing.
Single bench. 1 minute.
Lordship.
Item 1.
Lordship, it came up for hearing 2 weeks back. So while taking up the hearing matter, your lordship went through the judgment. So 3 persons were convicted. One of the connected appeal has come up, persons of your lordship's order. And we could not verify the registry whether the other person has also preferred any appeal.
Bhalla Sakmar Singh.
Plus, Valla Sankar, Sanjeev Sahu,
It was not,
Kapil Paul.
it was not, it will show. You have got a paper book? Huh? You collect the paper book. It will be common paper book, same judgment.
Lordship.
Collect the paper book. Okay. MS Bhuya,
Lordship.
Mr. Bakshi has not collected the paper book. Let him collect the paper book and cases be listed for hearing. Heard Mr. L.R. Majumdar, learned counsel for the appellant in 1. And Mr. D.K. Bakshi, learned amicus curiae for the appellant in item 2. Also heard MS B. Bhuya, learned senior counsel and additional public prosecutor for the respondent state. Also, it is submitted by the learned counsel for the parties that the 2 criminal appeals have arisen out of a common judgment and order dated 25/10/2021. Also, Mr. Bakshi has submitted that he has not yet received a copy of the paper book. Also, whereas Mr. Taludar and MS Bhuya have submitted that they have received a copy of the copies of the paper book. Received?
Lordship, I'll verify. Last
Let me
occasion, the matter came up for hearing.
Let me see.
Probably it was with me today.
We checked. Furnished. You have received copy of the paper book. Also, office to supply a copy of the paper book to Mr. Bakshi, learned amicus curiae for the appellant in so item 2. Within a week, also release the appeals for hearing
Online.
in due course.
Item number 3. Perhaps here, the paper book I have not received the paper book if I'm not wrong. My records.
Heard Mr. M. Dr. learned amicus curiae for the appellant and MS A. Begum, learned additional public prosecutor for the respondent state. Offense 302. Okay. Mr. Dr. Leonard Amicus Curie has submitted that he has not collected the copy of the paper book and has submitted that appeal be listed as he will collect the paper book shortly. Mr. Dr. Leonard Amicus Curie for the appellant is to collect the paper book within a period of 1 week. Release the appeal for hearing in due course.
Item number 4.
My casting here. Offense. Mr. Gogoi, Leonard Amicus Curie has submitted that he has not yet collected the copy, the paper book, and has submitted that he would collect the paper book within a week. List as the paper book is ready, list the appeal for hearing in usual course.
Item 6.
Please, Your Lordship.
Yes.
Lordship, in this case, I'm newly engaged in for appellant number 2, 3, and 4, Lordship.
Appellant number 2, why not 1?
One is represented by senior counsel.
What kind of practice is this? You should have filed different appeals then.
That same appeal, Lordship, same appeal.
Why entry of another advocate in this kind of practice is
I mean, not satisfied in charge, but that time and not 2, 3, 4 are taken back that treatment. Subsequently 2 days of
I don't know.
Today, Lordship filed.
This satisfaction during the pendency is not a proper approach, I think. Yes.
Yes,
What is your
Lordship.
submission?
IA for Lordship suspension of the sentence, Lordship, in this case.
Then
Lordship.
additional public prosecutor is to be given opportunity.
Then
Yes,
I've
Lordship.
seen the records, Lordship, office note says no steps taken, dated 31/7.
There is 2 IA. One representation.
No sign was 31/7.
No step taken. And as a PH. Okay, Mr. Ahmed submitted appellant 1, 2, 3, taken back the brief. Taken back the brief. You would recall it as a PH. Submitting an application. And what is the order initially? List the matter, admit the appeal. 302.
Yes, Lordship, 302. Lordship.
302.
Office note says
Office note.
head marks minor 31/7.
Office note. Compliance of the case have been received.
It's not in which, in the IAs,
Maybe it's
As a
like
call for listing.
31/7/2023.
31/7.
31/7.
We have already received the paper book, Lordship, in this case. Paper book is complete.
Have you got the paper book?
Yes, Lordship.
I hate objection. I was saying.
No negative objection.
Record out here, I notice. Miss Bhuya,
Lordship,
Conflict to IA.
की है? Office note. Anyway, in a main appeal, no notice was issued to the respondent number 2. I did not notice it. So issued respondent number 2 notice. We'll dispense with. Since you'll be representing
my lord.
the state. Yes, this application is for
Consideration.
appellant 1. Now there is another application for appellant 2, 3, and 4.
Yes, sir.
We have to issue notice in that. And I think you have filed any objection here?
No.
এটা separate তোমার তো objection finally বলতে না তোমার কি objection is
IA criminal 445/2024. Third, Mr. A. Mohammed, learned counsel for the applicant appellant, and MS B. Bhuya, learned senior counsel and additional public prosecutor, assisted by MS M. Chakraborty, learned counsel for the opposite party number 1, State of Assam. Post op. It has been pointed out by the learned counsel for the parties that in the accompanying appeal, criminal appeal number 268/2023, no notice was issued to the respondent number 2 while admitting the appeal by order dated (28/7/2023). Stop. It is thus submitted that the issuance of notice to the respondent number 2 can be dispensed with. Full stop. Having regard to the fact that no notice was issued to the respondent number 2 while admitting the appeal, the service of notice to the respondent number 2 in this interlocutory application under section 3829(1) CRPC is dispensed with. Full stop. MSV has sought for 2 weeks' time to find an objection on behalf of the state to the instant interlocutory application. Full stop. The prayer is allowed, leaves the case after 2 weeks. Full stop. IA 682.
Lordship, there is one more IFO 45
Ah.
wherein also
Be
we have not
Chowdhury.
filed.
We are
Yes.
issuing
Yes,
notice.
in two matters, we'll file objection.
Ah. I'm Mr. B. Chowdhury, learned counsel for the appellants, and appellants who are the appellant number 2, appellant number 3, and appellant number 4 respectively, the accompanying appeal, so and so. Also heard MS B. Bhuya, learned senior counsel and additional public prosecutor, assisted by M. Chakraborty for the opposite party number 1. Full stop. This is an application under section 389(1) CRPC seeking suspension of the execution of sentence passed against the applicant's appellants and for their release on bail. Full stop. MSB. Issue notice returnable in 4 weeks as MSB, who has appeared and accepted notice on behalf of the opposite party number 1, has sought for and is granted 2 weeks' time to file objection on behalf of the state. First, place the case after 2 weeks.
Earlier.
2 is enough or 3?
Since your
Three,
lordship
three.
is returnable 4 weeks, so.
No. Two
By
is good.
3 weeks we'll file.
3 weeks, 3 weeks,
Lordship,
3 weeks. Then it will be together.
fine.
Item number 11.
Huh? Offense?
Lordship,
Delay লিখি দিব পাৰিব? Delay condemnation? Order আছে না আগত? Delay condemnation. Learned legal counsel
yes, Your Honor.
for the appellant. And Mr. K.K. Das, learned additional public prosecutor for the opposite party, state of Assam. Full stop. The present application under section 5, Limitation Act 1963 is preferred seeking condonation of delay of 109 days, which is stated to have occurred in filing the accompanying criminal appeal against a judgment dated 9/1/2024 and an order on sentence dated 20/01/2024 passed by the Court of Learned Session Judge Kasar as Silsor in Sessions case number 107 of 2018, full stop, by the said judge an order on sentence, comma, the accused appellant has been convicted for the offense of murder under section 302 IPC, and he has been sentenced to undergo life imprisonment and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. We have gone through paragraph 234. Kekeras, hard on merits, sufficient cause, explain, delay, condone, to release the appeals after.
Third method for hearing,
Highly objectionable.
item number 18.
এই বসুমতাৰী আছিল এই আগৰ কোনে মাৰিছিল বসুমতাৰী কোনখিনিলৈ গৈছিল বা কোনখিনিলৈ গৈছিল নাই এতিয়া The place of occurrence was the house of the deceased and the accused, where the prosecution witness PW7, the daughter-in-law, that is the daughter-in-law of the deceased and the wife of the accused, also used to reside. Post up. The presence does the presence of PW7 and the place of occurrence was quite natural. At the time, in the house, when the incident of assault had occurred. Puस्तक এই আগৰখিনি কি আছিল বা নহয় আকৌ ৰিপিট হৈ গ'লে বেয়া হ'ব না মই পাহৰি গ'লো ন 6 was not to small extent. PW 1, 2, 3, 1, 2, 3. They did not depose anything as to how and when the incident of assault had occurred. You have to go to value 9. Okay, contradiction. All right, 155. PW6 হয়েছে PW6 হয়েছে PW7 হয়েছে হ্যাঁ PW7 হয়েছে PW7 হয়েছে এখানে বুঝিনি দা এখানে বললো না মাত্র এইটুকু কন্টিনিউশন এইটুকু on evaluation of the testimony of the responding number, sorry, PW7. No, on comparison. No, when the testimony of PW7 is read together with the testimony of The autopsy doctor, PW8, right side of chest. Back side করে গেল ব্যাক সাইড বলে গলে নাকি কোট বলে গলে আসলে autopsy doctor and a PME report. EXT4. There is no apparent inconsistency. Full stop. As per the testimony of PW7, the disease was assaulted by the accused by means of a Cipra. Cipra তো করেছিলেন এক্সিবিট হয়েছিল ম্যাটেরিয়াল এক্সিবিট within bracket an instrument, an iron instrument for digging art, bracket close. As per the seizure list, EXT 1, comma, a Ciprang with a bamboo handle of 3 feet long was seized by the IO at around 9 a.m. on 12/4/2016 at the place of occurrence, and the said Ciprang was produced by produced before the IO by PW7. Full stop. Comma, in presence of witnesses, comma, and thus seizure was made in presence of witnesses, comma, PW 1, PW 3,
Five,
and PW
five.
5. Full stop. It is neither the case of the defense that the prosecution witness PW7, that is the wife of the accused, was inimically disposed towards the accused, nor it is the case of the prosecution that the prosecution witnesses PW1, PW3, and PW5 were adversely disposed towards the accused having any prior enmity. First of the autopsy doctor, PW8, opined that had found abrasion of her right side of the chest, abrasions, and right leg. Full stop. The disease now. There was fracture of right clavicle. There were fractures of right clavicle and 8 and 10 ribs on the right side of the chest. As per the PW8 had opined that the cause of death was due to shock and blunt chest injury sustained by the disease. Trial court কি কইছে? Trial court 7 over কি কইছে? Era page. The learned trial court with the opportunity to form the opinion about the tenor of evidence given by PW7 and to examine the demeanor, had found PW7 as a reliable and trustworthy witness. Full stop. It is tried law that the appellate court, which had not this benefit, has to attach due weight to the appreciation of evidence by the learned trial court, unless so it is also settled that unless there are very significant regions, it is not proper on the part of the appellate court to reject the evidence on the ground of minor variations or infirmities in a matter of trivial details, if the core of the prosecution story has not been dented in any manner. Having regard to all the facts and circumstances obtaining the case, as discussed here in above, we are of the unhesitant view that the prosecution has been able to lead cogent and credible evidence to establish that the deceased, on the date of the incident, the deceased was assaulted by the accused by way of a Siprang, and the deceased died at the place of occurrence, either instantaneously or immediately after the assault. The question which has now arises for consideration is whether the deceased met his death due to an act of murder or for an act of murder or for an act of culpable homicide, not amounting to murder. Prosecution. Indian medium dot লিখিত শুয়ে কপি পেস্ট করে দিন ইয়াৰে ৰঙা পেৰা 27 28 29 bisa মোৰ হেৰিটো দিয়ক এই মোৰ টাইপ কপি যে টাইপ কপি bisa এইটো নালাগে বুদ্ধি সিংটো আছে নেকি আছে এই বিশ্বাস introduction 19 air 1958 SC 465 air 1958 SC
Lordship, have a look at my copy in a minute.
SC হলে বেশি ভালো air হলে বেশি ভালো চেষ্টা করে in Visa Singh versus State of Punjab, reported in AIR 1958 SC 465, which has attained the status of locus classicus, the Honorable Supreme Court, a three-judge bench of the Honorable Supreme Court, speaking through Vivian Bose, J, explained the meaning and scope of clause 3 of section 300 IPC. Gusto. Relevant excerpts. Relevant excerpts. No. It has been observed therein that in considering whether the intention to inflict para 11, the injury found to have been inflicted, the inquiry necessarily proceeds on broad lines as, for example, whether there was an intention to strike at a vital or a dangerous spot, and whether with sufficient force to cause the kind of injury found to have been inflicted. The inquiry is to be broad-based and simple and based on common sense. Full stop. It has been observed that the prosecution must prove the following facts before it can bring the case under section 300. Thirdly, Gusto. First, it must establish, quite objectively, that a bodily injury is present. Semicolon. Secondly, the nature of the injury must be proved. Full stop. These are purely objective investigations. Full stop. Thirdly, comma, it must be proved that there was an intention to inflict that particular injury, comma, that is to say, comma, that it was not accidental or unintentional, or that some other kind of injury was intended. Full stop. Once these three elements are proved to be present, comma, the inquiry proceeds further, comma, and fourthly, comma, it must be proved that there was an intention to inflict that particular bodily injury. No. Fourthly, comma, it must be proved that the injury of the type just described, made up of the three elements set out above, was sufficient to cause death in the ordinary course of nature. Full stop. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. Full stop. The court has went on to observe as under 16 ... The question is not whether, in this connection, it is also apt to refer to illustration C. To section 300 IPC. which mentions as under illustration 3. C2 assign C. A intentionally gives jade a sword cut or a club wound sufficient to cause the death of a man in the ordinary course of nature. Jade dies in consequence. Full stop here. Comma, A is guilty of murder, although he may not have intended to cause Jade's death. Full stop. Yeah. From the evidence on record, comma, it has emerged that the hearing, the disease was the father of the accused. Full stop. From the evidence on record, comma, it has emerged that the deceased was an elderly person of more than PM report to got us. More than 60 years of age. Is a man was a man of more than 60 years of age. $62 বুলি কৈছে নেকি? Who was aged about 62 years of age. Comma, as reflected.
40 years.
No. 62, page 55. Para 6. Page 55, para 6.
Yes, but person.
Dead body. As reflected in the inquest report EXT2 and the PME report EXT4. Full stop. It has further emerged from the evidence, from the testimonies of the prosecution witnesses who were known, who knew that disease, comma, the deceased was habituated to drink. Full stop. A chiprang, within bracket. An iron instrument. An instrument made of iron. For digging. Art kobo na soil kobo. Digging art. Bracket close. Is a moderately heavy. Wait a second. Moderately heavy,
It comes in different sizes. Worship.
but 3 feet.
I know.
Have you used
Yes.
sometime?
Yes.
Even
I
I had used it. Heavy object. Comma, no, not very sharp. Full stop. From the seizure list. EXT1. The Siprang siege was about 3 feet long with a bamboo handle. Full stop. If the assault, no, and the assault was made, assault on the disease was made. Not like assault was made. The chest is considered to be a vital part on the person, on the body of a person, on the body of a person. Full stop. From as per the medical evidence, comma, the chest injury sustained by the deceased was sufficient to cause the death of a person. Full stop. It is in such, it is in presence of such overwhelming evidence, comma, we have to consider view that the death of the deceased was an act of murder coming within the scope and ambit of clause 30 of section 300 IPC. Full stop. Para. The next issue for consideration is whether the case could come within one of the exceptions to section 300 IPC. More particularly, comma, exception 1 to section 300 IPC, exception 1 thereto, comma, as urged by the learned amicus curiae for the appellant. Full stop. Yes. Exception to Nana Boti Asna, Nana Boti Asna, Nana Boti. Nana Boti to very believable. Bishop in the Purina mentioned so what আজিকালি অকমান হেৰি কৰিছে হেৰিয়ে বেলেগ কৰি বেলেগ পিনে দিব বিচাৰিছে আৰু কৰি বিশ্বাস Oh. Hey. Ah, নাই exception 1 to here right নাই ঠিক আছে নানা বুদ্ধিটো আমাৰ ওলাই থোৱা আছে নেকি ঘৰত নাই এইটো তাতে আছে নেকি নাই মস্ত লম্বা on exception exception 1 is applicable when due to grave and sudden provocation, the offender, deprived of the power of self-control, causes the death of the person who gave the provocation. Full stop. The above exception is subject to the following provisos. Provisos, already quoted here in above. Full stop. Interpreting exception 1. What wrong are it? Interpreting exception 1 to section 300 IPC in K.M. Naravati versus State of Maharashtra, 1962. No, 1962. SUPP 1, supplementary 1. SCR 567. The Honorable Supreme Court has held that the conditions which have to be satisfied for the exception to be invoked are: A, the disease must have given provocation to the accused, semicolon. The provocation must be grave, semicolon. C, the provocation must be sudden, semicolon. D, the offender by the reason of the said provocation, should have been deprived of his power of self-control, semicolon. E, the offender should have killed the deceased during the continuance of the deprivation of the power of self-control, semicolon. And if the offender must have caused the death of the person who gave the provocation or the death of any other person by mistake or accident. For determining whether or not the provocation had temporarily deprived the offender from the power of self-control, the test is to be applied is that of a reasonable man and not that of an unusually excitable and pugnacious individual. Question. The question of loss of self-control is a question of fact. And the act of provocation and loss of self-control must be actual and reasonable. Company. It is clearly emerged from the evidence on record, comma, especially, yes, from the testimony of PW7, comma, prior to the incident of assault. The deceased had committed an indecent act of pulling the clothes of PW7, comma, who was the daughter-in-law of the deceased. Full stop. Such act was committed by the deceased when his daughter-in-law, comma, PW7, was sleeping. Full stop. It was at that point of time, comma, the accused had seen on his own daughter-in-law and his wife must have provoked the accused. Full stop. And an act of such pulling of clothes was amounted to outraging the modesty of his wife and the provocation was, and such provocation was grave, such provocation was sudden as well as grave. Full stop. It is not difficult to presume that such kind of grave and sudden provocation as a result of such grave and sudden provocation, it is not difficult to presume that such resulted into loss of self-control had resulted into temporary deprivation of self-control on the part of the accused, and finding a siprang, finding a siprang lying nearby, full stop. The accused at that point of time finding a siprang lying, siprang, comma, a tool easily available in a rural household, comma, lying nearby, picked up the same and inflicted the blow on chest on the person of the deceased, including the chest, including the chest. Inflicted the blow, মানে কি করবো? Blow, inflicted a blow on the person of the deceased. Pusto. The accused, being the son of the deceased, was quite aware of the age and bodily condition, physical condition of the deceased. Pusto. The blow given by the accused on the chest of the deceased had become fatal, resulting in almost instantaneous state of the disease at the place of occurrence itself. Full stop. Having considered this, the entire evidence stroke materials on record in its, having considered the evidence stroke materials in this, in its entirety, comma, we are of the considered view that It's 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 you know, you 44, no? 44. Email level 44, nahi? Raya. The act on the part of the disease is an act of culpable homicide of the second degree. Full stop. In other words, comma, the offense is culpable homicide not amounting to murder, comma, punishable under the first part of section 304 IPC. Full stop. Yes. What do you suggest? IPC concern?
Minimum 15 years.
Huh?
Accused person, my lord, is 32.
32.
He was, is it about 36 years? In 2018.
The
Oh, no,
accused
not- in
person, the
2022.
accused. P13. Huh? P13. The accused person is aged about 36 is presently aged about 38 years of age.
8. Already he had undergone 2 years, 5 months.
And has any point of sentence part?
Also, it's reflected in the
Ah,
cause list. 2 years, 5
he
months.
apart from his wife, comma, he has minor children. Full stop. There is it has not emerged from the case record that the accused apart from being implicated in the present case, comma, had any criminal antecedents. Full stop. Vera. Thus, comma, in the facts of the present case, comma, a sudden and grave provocation took place and the same would bring the offense within the scope and ambit of exception 1 of section 300 IPC. And hence, under section 304, part 1 IPC, as the accused had caused one bodily injury on the person of the deceased, comma, we are of the considered view that a period of a period of 8 years. 8 years. Of
Another 8
rigorous,
years. Another 8 years.
not 8 years. Period of 8 years, rigorous imprisonment of 8 years will meet the ends of justice.
Lordship, I pray minimum 10 years. Now he has killed his own father, man.
Father, under what situation? Hmm? Ah. Hmm. কিমান লৈ আছে? কিমান লৈ দিয়ে? কিমানটো কিমান? Extend to 10 years. Nicholas Cook. Nicholas Cook. Bodily injury to the disease. Which, comma, to his knowledge, comma, was likely to cause the death of his father, likely to cause the death of the disease, comma, who was his father. We are considering so and so, 8 years of rigorous imprisonment. Full stop. So the fine of rupees fine imposed by the learned trial court is along with the default stipulation is maintained, is to be maintained. Full stop. Accordingly, comma. This criminal appeal is partly allowed by converting the conviction of the accused appellant from under Section 302 IPC to Section 304 Part 1 IPC. And the sentence is altered from rigorous imprisonment to for life to rigorous imprisonment for 8 years. And by maintaining the fine imposed upon the accused appellant with default stipulation as passed by the learned trial court. Full stop. Para. We reiterate the direction given by the learned trial court as regards award of adequate compensation to the family of the victim in terms of Section 357A CRPC and under the victim extant EXTANT victim compensation scheme framed thereunder. Full stop. Para. The period of detention, it is observed that the period of detention already undergone by the accused during the course of investigation, inquiry or trial shall be set off against the term of imprisonment in terms of Section 428, CRPC. Maintaining the fine out. Better. Amicus thinking. Appreciation, amicus. Result. Case records to be sent back forthwith. Any objection regarding the term of imprisonment?
I leave it to your lordship.
Well, situation was grave.
Situation is great. At the same time, my lord,
We
injury was fatal.
We looked into the trend of Honorable Supreme Court also, of this court also, regarding the term of punishment. We find that that is a normal practice ranging between 6 to 10 years under Part 1, 304. So, in between we have given. Hey. Wrong idea, sir. This is which are treated to be proved by the learned trial court as outlined in the judgments to complete the chain of circumstances leading to the or pointing towards the
Guilt.
accused appellant that they are a probable assailant. And many other issues would come. So what do you say about this? Let us see exhibit 6. Exhibit 6 is
Is 108,
108, my lord.
statement of accused Viren plus.
This is under 161, my lord. And I'll be relying on your recent judgment of this court only, lordship. Passed in Vishnu Urangia, my lord.
Huh?
Lord, in recent judgment of this court, my lord, in Vishnu Urangia, my lord has referred to Kartha Singh case and from section 24 to 30, my lord has given the detailed observation with reference to evidence at section 24 to 30, my lord. That judgment I'm going to rely, your lordship judgment only. Because, my lord, the first page, I've just given a, my lord, note, my lord, a small note, my lord, I've prepared, my lord. My lord, these are the 6 circumstances where in the trial court has relied in convicting the accused persons, my lord.
Let us have the trial court first.
Yes, my lord.
That will be clear. So for testimony is concerned, okay, we have
My lord, then my lord,
substantially read those.
page 71, para 42 would be relevant from there itself, my lord.
Page
71, my lord. From para 42, my lord. I'm sorry, my lord. I'm sorry.
Okay, firstly, we term Bapan. You are representing Bapan Datta.
I'm Viren Das, my lord.
Viren. Okay. Let us name Viren Das as A1.
Yes.
So that and Bapan is A2 and the DG is A3. Okay. So you are Viren.
Page 70.
You are Viren.
I'm Viren, my lord.
So you are A1
Even.
and you are A2. Okay, paragraph 42.
No, my lord, para 45. From para 45, page 73,
No,
my lord.
one thing, just one, read one
Yes, ma'am.
once, paragraph 42.
In the cross-examination of PW 15, the investigation officer has disclosed that FIR was lodged on 2011-16. Accused Bapan was arrested on 22-11.
A2.
A2.
Okay.
And Biren Das was arrested on 21-11-16 at about 6 p.m. The discovery was at 10:30 morning. From this, my lord, extract of the GD entry, my lord. I'll just take your lordship to the GD entry once for page, my lord, 111.
This is JD entry number what?
My lord, only 4 is written on the left-hand side amount. Thereafter, my lord, time is written. And this is one of
No, it
the
is
extract.
exhibited. So
Yes, exhibit 7, my lord.
what is the GD entry number? Please tell me.
Well, that
This is typing thing. This has been typed. So what is exhibit 7 GD entry number?
sorry, my lord. I did not see the records, my lord.
You don't know?
No, my lord.
Exhibit 7. How exhibit 7? Okay. This is what?
PW 15, my lord.
Exhibit 7. Who said PW? Who exhibited it?
PW 15, my lord.
15. 1, 15.
Page 29, my lord. Cross part, evidence part, my lord.
29.
29.
His note.
This is my note as to recovery of the dead body as per the statement of the accused Biren Das.
This is 20 or 21.
My lord, FIR is
Date.
FIR is 20 and recovery is 21.
This note.
This note.
कैसे है? No, yes, there you can. What in 30? Well, we have find out from this where is this note at 10:30. This 111. And also 161 statement of A1, Birendas. So for Mr. Tiwari, reply of defense,
Yes, my lord.
paragraph 3,
Yes, my lord.
you read about, stated about page number 95.
Yes, my lord.
Whether the Birendas was arrested on 21/11/2016 and about 6
6 p.m.
p.m. and say leading to discovery at 10:30.
10:30.
Say assume.
Yes.
Whether it really matters.
It really matters, my lord. Because, my lord, in the examination of PW1, my lord, Ajay Deka says that his person.
No, I'm Mr. Tiwari, please
Yes,
understand the question and answer it.
I'll try.
Don't jump in here and there. That arrest of Birendas at 6 p.m. on 21/11/2016 and discovery of the dead body inside a septic tank in the morning hours of that day, whether it really matters under section, just with these facts,
Yes, ma'am.
Don't go,
My lord,
please,
I'll not go.
please.
I'll not go, my lord.
Whether it really matters under section 27.
Yes, ma'am.
How?
Because, my lord, it was A3 who initially informed the informant Ajay Deka.
Please, Mr. Tiwari, only with these limited facts.
Because
We'll go into the other areas later on, Mr. Tiwari.
then, my lord,
When a specific query with these facts, in the context of 27, whether it really matters, without going into any other thing, your paragraph 3, I'm asking you, again repeatedly and pointedly, don't go to PW1 or don't go to anywhere else. Please don't travel beyond paragraph 3. Please. This part that A1 was arrested at about 6 p.m. on 21/11/2016. Right. And he could not have led to the discovery of the body at 10:30. Only this part.
my lord, because the 161 the IO is referring to, my lord, says that on being led by Biren, the body was discovered, my lord. So that part will not come. That apart, my lord, the discovery as per the other, my lord, PWC also, the weapon was also seized on the same day.
Okay, Mr. Tiwari.
So, my lord,
That's all, that's all, that's all.
161 and my presence in the morning.
No,
at
Mr.
10:30, my lord,
Tiwari,
are
please,
discovered.
when I asked a query, don't travel beyond that, that's all. Yes. Don't try to mix up all issues and to jumble up and to throw it to the court. When I asked a specific query, answer to that query. I want to see it because many times translation creates a havoc that we found out on that day. A word here and there wrongly translated makes a whole lot of difference.
One tuka I have found, my lord.
That took a resemblance, page 111.
Sabasin ko na, 111 GDN.
111.
এতিয়া মই গুচৰিয়াই সমঝাই দিয়া এই গোচৰ সন্দেহী হত্যাকাৰীজনক থানাতে পায়।
1 minute, 111.
7:30 অপৰাহ্ন।
1 minute, 111.
এতিয়া মই গুচৰিয়াই সমঝাই দিয়া এই গোচৰ সন্দেহী হত্যাকাৰীজনক থানাতে পাই তেওঁৰ গোচৰ সম্পৰ্কে সোধপোছ কৰি তেওঁৰ জবানবন্দী বেলেগে লিপিবদ্ধ কৰি পঞ্জী
But that is not 111. Oh, holy. Okay. Look into it. How many witnesses? 16.
16, my lord.
And what are the exhibits? Teacher. With postmortem statement. Papon Datta. Confessional statement was there.
Yes, my lord.
How many?
2 statements, my lord. One of A2 and other one of A3, my lord.
Let us see 122.
122, my lord.
Any infirmity in the procedure?
There are.
Tell me, any infirmity, reflection time was given. He was produced from judicial custody. Sufficient time for reflection. No direct contact with the investigating agency, it appears. Regarding a procedure,
Procedure, my lord, there is. But my lord, there was an injury in A2.
What is page 30, sorry, 147, 153?
My lord, the confessional statement of 147 is the confession of A3, my lord.
Oh, sorry, 133, 133, I'm sorry,
132, my lord.
133.
My lord, Umesh Deka, my lord. Twice the statement as my lord annexed in the paper book, my lord.
Oh, 1 minute. Mr. Tiwari, you seem to answer when to a one question, four answer.
I'm sorry, my lord.
I don't have IA in my mind, AI. This is Umesh. Not exhibited. Not exhibited,
No, no.
Miss Mia.
Lordship.
This 133, page 133.
Exhibit for an
Let us see the IO. Let us get the facts clear.
IOPW 15.
15.
Page 28, my lord.
Did he exhibit this? Not exhibited?
But my lord, PW 16 has exhibited
Send me
the
that.
confessional.
Not exhibited or exhibited?
Not exhibited.
That's all. Then MS Puya, come to page 83.
Lordship.
Roman 6.
Accused Papan Dotto and another co-accused Umesh Deka, who had already expired, have confessed their guilt by implicating the accused for causing the death of accused and their part for concealing the dead body in septic death.
It was taken into consideration.
Lordship.
Umesh Deka, A3. He expired.
He expired.
So what is the content? Page 133.
Page 137.
137.
I worked in the construction of a water plant at Uttar Kalikota. In the night on 4/11/16, we four persons were in a room together. In the evening on the same day, an altercation took place between Goranga and Biren, as Goranga took almost rupees 15,000 more than his due. Having meal thereafter, we went to bed at about 8 p.m. Around 11:30 p.m., I felt something grating at my feet. Then I woke up and saw Biren standing with a crowbar in his hand. I saw Goranga dead and blood was oozing from his mouth. Thereafter, he put a cement sack on the head of Goranga and asked Bapan and me to hold the dead body of Gauranga.
Hmm.
That is
So
the-
how the confessional statement of Umesh Taka was taken into consideration by the line,
Right.
under what principle? Can you throw some light, say for page 83, condition 6, circumstance 6. Accused Bapan Datta. We'll consider that in another matter. Another co-accused, Umesh Deka, that who came to the informant,
Yeah.
who had already expired, had confessed their guilt by implicating the accused for causing the death of the deceased and their part for concealing the dead body in the septic tank. Now, how this confessional statement of Umesh Deka can be taken into consideration by the learned trial court? Because para 53 starts with, after close scrutiny of the evidence on record, the following circumstances have been brought on record. Right? Now, in what manner, under what principle of law? Can you throw some light? Because these are the circumstances trial court took note of. Hey, evidence and conviction, evidence. It was not brought on record.
My lord.
Something which was not brought on record, can it be used by the learned trial court?
Also, section 30 of evidence said.
No. Now, this man died,
While he died,
and secondly,
it was not exhibited.
not exhibited. And magistrate was, okay, let us see magistrate. Who is the person, 133, who recorded?
Magistrate PW 16.
NC Bhuyan.
NCB.
Okay, let us, magistrate NC Bhuyan.
Page 30.
Magistrate,
Lordship, 25, 11, 15.
doctor, right?
Dr. MC, yeah.
Dr. NC Bhuyan. Okay, he is PW
PW 16. Who expired?
PW 16. His testimony, page 30. Bapan.
Umesh.
He's silent.
His name is Umesh, not Bapan.
No. There are, Miss Bhuyan,
Lordship.
there are two co-accused, A1, A2, A3.
Yes, one
We
expired.
are speaking, we are concentrating on A3 right now. We'll come to A2 later on. Now, so far A3 is concerned, PW 16 did not exhibit his
No, it doesn't talk about
Huh?
A3.
So, can it be treated as a dying declaration? Hmm?
Lordship, then time period when it was recorded, the relevant factor.
Sometimes rigidity for dying declaration is not same as other confessional statement.
I know.
Now, is it a dying declaration? He died.
He died, but
He died.
may not be, my lord, may not be. My
Not
limited
may not be.
knowledge. It won't be.
Must not be.
Must not be. My
Not may not be.
lordship, but because by dying declaration has to be as to the cause of his death.
Own date.
Own
Yes.
death.
Not be.
Somebody others date.
Not be. Lordship.
Not, it is not, it cannot be treated as a statement under section 32 also. So how the learned trial court or the prosecution without exhibiting it can bring it on record? Am I clear? So it is neither brought on record, it was neither brought on record, nor can it be treated as a dying declaration within the scope and ambit of section 32. If it is not, it is to be excluded out of consideration.
Then
Then
the,
that a circumstance which relied on by the trial court is not valid.
one of the circumstances.
A3,
Yes,
that
yes,
circumstance.
my
We are dealing with now one circumstance,
Yes,
A3,
my lord.
that he implicated the A1
And
for the death of the disease.
yes,
That part is to be excluded out of consideration. That cannot be a circumstance, right?
lordship.
Then comes the confessional statement of A2,
A2.
right?
Yes.
Now let us see.
Kapot doctor, no? 122. Exhibit 11.
And what are the other? There are many. What are the other? 147, 140. What are those? 140 and annex twice or what?
Twice, madam.
Huh? Double recording or annex twice?
And next twice, madam.
Annex twice. Okay. So reading one will do.
Please
Then
note
let
down.
us read that page 122.
Relevant portion is page 127.
122, 127. Okay, procedure is complied with. Let us assume for the time being, unless I have seen one injury on the head, but it has been explained.
Lordship.
One injury on the head of A2 was noticed, and the learned magistrate has explained after inquiry that he sustained injury falling on a stone.
Yes.
He should have been probed deeper, but anyway,
Lordship, may I read?
yes.
Umesh Teka, Viren Das, Gaurango Das, and I worked in a construction project at Uttar Kalikhola in the week before last week. In the night of occurrence, Umesh, Biren, Gauranga, and I were sleeping in the same room after having meal. In the evening that day, an altercation took place between Biren and Gauranga regarding accounting of money. Hearing scream all on a sudden in the night of occurrence, I woke up and saw Gauranga lying on the ground. There was blood near his head. Biren had an iron contis in his hand. Later, Biren asked Umesh and me to hold the dead body of Gauranga. Then we three of us dragged the dead body of Gauranga and threw it into septic tank. I only knew this much.
Now, query of the court to Mr. Tiwari and to MS Bhuya. How this confessional statement is to be treated? Keeping in view the provisions of the Evidence Act.
Section 30 will
Okay, okay. How?
Lordship, some of the factors of section 30,
Now, if we look
my lord.
to this statement, let us read 130, then I'll ask the query. Do you have the Evidence Act, Mr. Tiwari, with you?
Yes, madam, I'm reading it.
When more persons than one are being tried jointly for the same offense, and a confession made by one of such persons affecting himself and some other of such person is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession.
Read illustration A.
Illustration A. A and B are jointly tried for the murder of C. It is proved that A said B and I murdered C. The court may consider the effect of this confession as against B.
Okay, B also.
A is on his trial for the murder of C. There is evidence to show that C was murdered by A and B, and that B said A and I murdered C. This statement may not be taken into consideration by the court against A and B is not being jointly tried. But in this
B is
case,
not out of,
no.
B is not applicable. Now, again, A.
A and B are jointly tried for the murder of C. It is proved that A said B and I murdered C. The court may consider the effect of this confession as against B. But in the, yes, I have to differentiate it. In a case in hand, hearing scream all on a sudden in the night of occurrence, I woke up and saw at page 127. I woke up and saw Goranga lying on the ground. So the previous event probably have not seen it. There was blood near his head. Biren had an iron conti in his hand. Later, Biren asked Umesh and me to hold the dead body of Goranga. Then we, three of us, dragged the dead body of Goranga and threw it into septic tank. I only know this. So, Lordship,
Charges are 2.
yes.
302, read with 34. And charges are 2, I am saying.
My lord.
302, read with 34. And 201, read with 34. Now here, he makes the confession about 201,
My lord.
implicating himself
Sir?
and A1.
Yes.
But so far as
302
302 is concerned,
He's manipulating me.
what did he say?
Lordship,
His statement was exculpatory.
yes, my lord. Exculpatory.
So, how did you treat this confessional statement in the context of section 30?
Lordship, as
Whether this will be admissible in evidence? Yes.
as it
Anything?
is Bapan Doctor,
Anything? No.
On this
No
point-
preparation?
No, otherwise I have brought a recent judgment of the Supreme Court. Madam.
Don't know on this point. On this point.
On the particular point, I don't have.
Lordship, as against Bapan Doctor, he may be made liable for under section 201 because there is no like.
Now, whether this.
But as against the
this-
other person,
no,
Lordship,
no, my query is now.
my lord.
See, this A2 has implicated himself with A1
Yes.
and A3 for the offense under section 201,
Yes.
right? In furtherance of common intention.
Yes.
Now, let us assume for a moment. But A2 has made his confession is exculpatory so far as the offense under section 302 is concerned. Right, right. As well as he did not implicate A3 for 302. What he has given inference that A1 might be involved for the offense because he said that he did not see. He woke up, saw Goranga lying on the ground and there was blood near his head and Biren had an iron conti in his hand. So basically immediate post occurrence.
My lord.
Now, the query from our side is to the council that this statement is acceptable as a whole or partially, or it should go all together,
Lordship
go out of consideration for all together.
may be accepted as a whole because your Lordship 34 is there. They are vicariously liable for act of another person.
Well, I'll say it will inside
Stay
the
will
court-
not do. What is the authority on
My
it?
lord, authority, my lord.
You are the counsel to assist the court.
My lord, correct, my lord. I brought a judgment not on the specific line which the
No,
court
this
has
is the
indicated.
point.
Correct, my lord. That is why, my lord, every day we are learning, my lord.
If this goes, another thing goes. If this is accepted, then other things will come. Section 27 will come, will treat that exhibit 6
And your
and
lordship,
we may, how to accept it. So we are dissecting the case point by point. Now tell me, what is the position of law? Yes, Mr. Mohanta.
Insofar as Bapon is concerned.
No, don't bapon. I am saying this treatment of this particular statement, confessional statement of A2 in the context of section 30.
That, my lords, I have to go into.
If A goes down, A2 goes down.
Now, my lords,
lordship got a judgment. If common intention is proved, my lord,
Common intention law, we are context of section 30.
section 30.
This might go altogether.
Altogether.
If this goes, prosecution case will lose another limb.
Lordship, but
My-
yes, yes,
If this stands,
my lord,
then your case will be strengthened.
my lord,
So that is the anything hinges on it.
my lord. And they also owe an explanation under.
No, I have not
106.
come across also. So let me be fair.
Bapon otherwise has a very good case. My lord.
Oh,
Anyway,
wait, if it goes down, everything goes down. 34, liable in the same manner, Mr.
I've
Mohanto.
got judgments on 34, my lord, not at all
No,
liable.
No,
201, 201, it is there.
3 years, my lords, I've already suffered 7 years now.
Firstly, on the point of law,
My lord, that might learn it should not address, my lord, because I'm only concerned with 34. If that goes, my lord, I'm.
Not yet, you speak so. Every time you know.
evidence act. এই কিতাপ এখন আছে পুৰণি এভিডেন্স এক্ট কিতাপখন আছে আমাৰ ডাঙৰ এভিডেন্সৰ কিতাপ আছে নেকি এই সেইদিনাখন দেখিলো মই some ingredients are matching.
My lord,
More persons than one are tried jointly for the same offense. So
offense.
302 and 201.
yes,
And a confession made by one such person affecting himself
yes,
and some other of such person is proved.
my lord,
The court may take into consideration such confession as against such person as well as against the person who makes such confession. Now, A2 is making confession regarding 201. That is 201 inculpatory to himself and to A1 and A3.
lordship,
But A3 abated, that is a different matter. But so far as 201 is concerned, that is an inculpatory statement. So far as 302 is concerned, A2 has made an exculpatory statement so far as against him, implicating A1 somehow related with the date of the deceased.
my lord, lordship,
If we dissect this statement, so prima facie, this part that pointing towards A1 is concerned, nothing can be derived by the prosecution from this statement in respect to the offense under 302.
2, lordship. But your lordship, they were sleeping in the same room. no effort from their
No,
side.
No, we are on this particular,
Yes.
exactly only this particular
Sure.
thing. We are not going into circumstances. We have not discussed anything right now.
Lordship. My lord,
We are on the admissibility of this confessional statement
my lord,
and how far and to what extent
yes,
this confessional statement can be admitted into evidence in the context of section 30 of the Evidence Act. That is what we are discussing. Huh? Yes. AR 57 and 1957 Supreme Court 216. Yeah, probably MS Bhuya, one interesting observation.
my lord,
Though from Privy Council and others,
lordship,
I have only read the head note,
my
though reliance should not be placed on
Yes,
head
head
note
note,
but
my lord.
short note. Co-accused implicates
my lord,
another for murder. Okay,
my lord,
implicates another for murder and implicates himself for disappearance of the dead body. Exactly like us.
Us.
Such confession is inadmissible against the co-accused.
It goes against us.
It is likely to go against you. And otherwise, this is not substantive piece of evidence. Bit weak.
My lord,
আচ্ছা আরো একটা ডিরেকশন এইটা কভার পাই নাকি এইটো অপশন পাৰি নেকি নহলে আনিব লাগিব ইগনোর থাকে নহয় That part may not remain so far, 302. Out of this confessional statement of A2, that he was pointing towards A1 regarding A1's involvement with the death of the deceased is to be excluded out of consideration.
Lordship, I'll also check. I may be given an opportunity
Okay.
to do some research.
That part. Secondly, whether it is a case of leading to discovery, that have you marked the statement
Yes, ma'am.
of EXT?
EXT
Six.
7, 6, I didn't get your lordship.
Uh,
That took out.
that is not.
That note is
I had a
not-
look. I had a look at the
She found it.
note and that disclosure statement. But
Lordship.
after glancing through, I did not find it.
Even I didn't find. Somewhere it has been mentioned as exhibit
That is
7,
the.
but it has been cut.
Huh?
In one place, I have found exhibit 7 at page 46.
You know, one more thing.
I know.
We will come to the disclosure statement. Page 108. This is the story.
108.
This is the story
I know.
of A1. Right? Now, see the last line. That is why I wanted to see
Last line of 108.
page 110.
110. I showed to the police the place where I had kept the dead body hidden.
Yes.
110.
Lordship.
Is it really a statement before leading to discovery? Or is it a statement post discovery? To bring into operation section 27.
Lordship,
I showed past tense.
yes,
I will show
I know.
it would have been a leading to discovery.
Discovery.
But I showed it is a fait accompli.
I know.
The seizure was fait accompli. Seizure means the body.
Body, yes.
I showed to the police the place where I had kept the dead body hidden.
I know.
So, is it really a statement which is responsible for leading to discovery, or it is a post-discovery statement? Then if it is a
seems-
post-discovery statement, it has no value, goes whole hog.
Yes. Some of the witnesses has said.
So
local
that
public
will take care of it
Yes.
later on.
Yes.
Later on.
Lordship.
But whether this is really, that is why I requested. Actually,
Lordship,
this is the
orange mark-
reason
Orange mark
behind
portion-
requesting you where is the disclosure statement in the case diary.
Yes, it's there. One was exhibited of this Birendas.
Ah, marked as exhibit 6. Where is that? Red
Yeah.
mark.
Yeah,
Let us see.
but no, exhibit 7 is not there, but exhibit 6.
Now, it is a wrong due to translation or wrong and correct representation of fact. That is what I want
Yes.
to know.
Exhibit 6.
Sometimes, as indicated,
I know.
translation creates a havoc. Huh? Sunday.
Excuse me. দুটো অরেঞ্জ কিনি না বিলাল অরেঞ্জ অরেঞ্জ
যোৱাকালি সন্ধিয়া, that is 2011, মোক আৰু উমেশ ডেকাক ঠিকাদাৰ অজয় ডেকা আৰু তেওঁৰ মানুহে consistent with FIR মোক আৰু উমেশ ডেকাক ধৰি আনি পানেৰী থানাত সমজাই দিছে। মোৰ কবলগীয়া ইমানেই, মই পুলিচক মৃতদেহ লুকাই থকা ঠাই দেখুৱাই দিছো। Not a statement to be admissible under section 27.
Yes, the leading part. Leading, he should lead the,
Statement should have been earlier,
my lord.
discovery should have been later. Now here is a case, cart before the horse.
My lord. So time factor.
Discovery was earlier,
Statement
statement was later.
I've not
Then
seen the time, my lord. Time,
27 goes,
lordship time factor,
Huh?
time, what time?
দেখুৱাই দিছো already, that is,
Already
দেখুৱাই
it was
দিছো,
shown, yes.
fate accompli. যোৱাকালি আমাক
Well, I understood.
যোৱাকালি আমাক অজয় ডেকাই সমজাই দিলে, and he explained the reason why he has killed the deceased.
Yes.
But the concluding part is, মই পুলিচক মৃতদেহ লুকাই থোৱা ঠাই দেখুৱাই দিছো।
Already shown.
Already indicated. It should have been statement recorded. Thereafter, he went there and
Chose the.
then on the basis of this statement, that septic tank, police, that place, Munshi, Bosti, went there, found the dead body.
Then 27 goes,
Then comes
64.
section 8.
Yes, relevancy.
Then even if conviction can be based on section 8,
And your lordship will consider other circumstances.
then we'll see. But so far, these are the tricky part. 27. 27 is not material, but still, section 28.
And
Oh, sorry, section 8.
8 of the.
The other part. Okay, what we do, what we propose to do. Let us take this evidence part,
Hello.
factual part on record. You address on this point tomorrow. No later than tomorrow. I'll forget.
Lordship,
I experienced difficulty after 48 hours to dictate.
Lordship.
The
tomorrow,
today's-
Mr. Tanmoy Mohan does matter.
That will consider.
Yes.
Have you come across any
Yes.
good one there?
Lordship, with the 3 judges, I've already placed it on Adade Jayaprakash.
Okay, we'll see that.
Yes.
You hand it over.
Yes, it was
Huh?
already informed on the last occasion.
Matak. We'll put down the testimony part. But section 8 is also dangerous as section 27.
I'm reading out that only.
Huh?
I'm reading out that only, my lord.
It is as dangerous as section 27. Since you have exhibited this disclosure statements, I think some, I might say,
No, no. I know.
Both these criminal appeals from jail under section 383 Code of Criminal Procedure, CRPC code, have arisen into court out of a common judgment and order dated thirty 2021, passed by the Court of Learned Session Judge Udalguri in Sessions case number 41 of 2017. Full stop. The criminal appeal criminal appeal J, within bracket J number 29 of 2023 is preferred by the appellant, Birendas alias Bira, within bracket hereinafter referred to as A, quote unquote, A-1 for easy reference. Full stop. The other criminal appeal J number 26 of 2022 is preferred by the accused appellant, Bapan Dutta, within bracket hereinafter referred to as A2 for easy reference. Full stop. In the trial of Sessions case number 41 of 2017, these two appellants, A1 and A2, faced a charge of murder for the date of the alleged homicidal death of one Urango Das or Nath? Nath. Das or Nath?
Das.
Das. Das. Along with another accused person, Umes Deka, within bracket hereinafter referred to as A3 for easy reference. By the common judgment and order dated 30/11/2000, so and so, both the accused appellants have been convicted for the offense under section 302, Indian Penal Code IPC, in aid of section 34 IPC, and also for the offense under section 201 IPC, in aid of section 34 IPC, holding that they, in furtherance of their common intention, committed the murder of Gauranga Das. Within bracket, the deceased. Oh no, within bracket, hereinafter referred to as the deceased for short, for easy reference. Full stop. For the offense under section 302 IPC, read with section 34 IPC, the accused appellants have been convicted, have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 each, in default of payment of fine, to undergo simple imprisonment for another 6 months each. For the offense under section 201 IPC, read with 34 IPC, section 34 IPC, each of the accused appellants has been sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 2,000 each, in default of payment of fine, to undergo simple imprisonment for another 1 month each. It has been ordered that both the sentences are to run concurrently. Full stop. As it has been mentioned, the trial of sessions case number 41 of 2000 was regarding homicidal death of Gauranga Das. The sessions, the case, sessions, case number so and so, arose out of Paneri Police Station case number 75 of 2016 and corresponding ZR case number 1180 of 2016. Full stop. The crime case, Paneri Police Station, case number 75 of 2016, came to be registered pursuant to lodgement of a first information report by one Ajoy Deka as the informant before the officer in charge, Paneri Police Station on 2011-2016. Full stop. In the affair, the informant had inter alia mentioned that the informant No, in the final. The informant is a resident of Ward number 4, Tongla Police Station, Tongla. Full stop. In the affair, the informant inter alia mentioned that he was executing a contract work of construction of a water tank under the aegis of the Public Health Engineering Department at Munsibosti North Kalikhola under Paneri Police Station for the last 2 months, and one Gurango was engaged by him as a head mason for his said contract work. Poster. The informant further mentioned that some of the laborers were engaged under the head mason, Gorango. Poster. When the said contract work was undergoing, one person named Umesh Deka, A3, who worked with the head mason, Gorango, came to the house of the informant at Tongla at around 4:30 p.m. on that day and informed the informant that the head mason that two fellow workers of the head mason, Gorango, Vijay, Biren Das, and Bapon Dotto, A1 and A2. After killing Gorango, dumped the dead body of Gorango in a septic tank. The informant further stated that the murder of Gorango was committed some 14-15 days ago. By lodging the FIR, the informant requested to carry out an investigation into the matter. On receipt of the FIR, the officer in charge, Paneri Police Station, registered the same as Paneri Police Station case number 75 of 2016 on 2011-2016 for the offences under sections 302/201/34 of the IPC. The officer in charge, Paneri Police Station, assigned the case to one Robin Sondro Deka, a sub-inspector of police attached to Paneri Police Station to investigate into the case. Poster. after most of the uh, after investigating into the case, after on being assigned with the investigation comma, the IO province Karnataka PW 15. Completing investigation into the case, comma, submitted HR sheet under section 173 to CRPC. Right. Sarsit number 05 stroke 2017 on 23/3/2017, finding a privacy case well established for the offenses under section 302 201 stroke 34 IPC against the three accused persons. 1. Biren Das alias Bira A1. 2. Bapan Dotto A2 and Umesh Deka A3. Fair. On submission of the search sheet, comma, the Court of Learned Chief Judicial Magistrate, Udalguri, issued summons to the accused, Umesh Deka A3 for his appearance before it, as he was allowed to go on bail in the meantime. Also, on 8/6/2017, the accused Umesh Deka A3 appeared before the Court of Learned Chief Judicial Magistrate, Udalguri. On the same date, the court also secured the appearance of the other two accused persons, Biren Das A1 and Bapan Dotto, from judicial custody. After appearance of all the three accused persons, the Court of Learned Chief Judicial Magistrate furnished copies to all of them in compliance of the procedure laid down in section 207 CRPC. As the offense under section 302 IPC is exclusively triable by the Court of Sessions, the Learned Chief Judicial Magistrate, by an order of commitment dated 8/6/2017, committed the case records of GR case number 1180/2016 to the Court of Sessions, Udalguri, for trial. The accused, Umesh Deka A3, was allowed to remain on previous bail on an application filed on his behalf. The custody of the other two accused persons নামটো লিখি দিব বীৰেন দাস A1 and বাপন দত্ত A1 বুলি ক'লে আৰু নামটো লিখি পেলাই ভিতৰলৈ was converted into committal custody. Full stop. The learned public prosecutor was notified accordingly. Full stop. And the case was posted on 15/6/2017 next for appearance of the accused persons before the court of sessions. Full stop. Para on receipt of the case records of CR case number so and so, comma the court of sessions. Yes, Udalguri, no? Udalguri. Registered the same as sessions case number 41 of 2017. Full stop. The case before within bracket the trial court or short. The case before the learned trial court was opened by the learned additional learned public prosecutor. Ikite Moril. এইটো উমেশটো চাৰ্জৰ সময়ত আছিলে না he was alive at the time of framing charge.
Yes, sir.
Okay. After hearing the learned public prosecutor and the learned defense counsel and upon perusal of the materials available in the case record, comma, the learned trial court, comma, on, comma, 28/06/2017, comma, had framed the following charges against all the three accused persons. Page 6. First, second. When the charges were read over and explained to the accused persons, comma, the accused persons pleaded not guilty and claimed to be tried. Full stop. Accordingly, comma, the trial court proceeded with the trial. Full stop. During the course of the trial, comma, the prosecution side examined 16 number of prosecution witnesses, and they were page 91. Full stop. In addition, comma, the prosecution side exhibited 11 number of documents, namely page 92. After closure of evidence from the prosecution side, comma, the accused was during the pendency of the trial, comma, the accused person Umesh Dekayatri had expired, and as a result, comma, the case stood abated against him. Consequently, comma, the trial continued against the other two accused persons, comma, Biren Das A1 and Bapon Dotto A2. Umesh Deka was examined under 313? No. Full stop. After closure of evidence from the prosecution side, comma, the two accused persons were examined under section 313 CRPC, and they were provided with the opportunity to explain the circumstances which incriminating circumstances appearing from the evidence of the prosecution witnesses. Full stop. Kiba plea লৈছিল নেকি? Kiba plea লৈছিল নেকি? He wanted to লৈছিল নেকি? Wrong song. The plea of both the accused persons was denial. Full stop. When they were asked as to whether
Death certificate of. Fine. 132. As per EO's report, Mano, date certificate has been annexed, which is exhibit X2. I could not find it, Mano. Page 132, something else. Very bad.
whether they would deduce any evidence in their support. Full stop. The accused persons had, however, declined to adduce any evidence in their support. Full stop. Thereafter, the learned trial court proceeded to hear submissions of the learned counsel for the parties. Full stop. After hearing the learned counsel for the parties and upon appreciation, evaluation of the evidence stroke materials on record, the learned trial court delivered the judgment and order, impugned hearing. Full stop. Fair. We have heard Mr. A. Tiwari, learned counsel for the appellant, Biren Deka alias Bira A1, and Mr. P. Mohanto, learned counsel, learned amicus. Amicus, you for the appellant, accused appellant, Papan Dotto A2. We have also heard MSP Bhuya, a learned senior counsel and additional public prosecutor for the respondent state, assisted by MS M. Chakraborty, learned counsel. M.
Ardas.
Ardas. Yes, your submission, some document, or you have placed, right? Mr. Tiwari. First page is trial court circumstance.
Yes, madam.
Second page is okay. Mr. Tiwari, learned amicus curiae appearing for the appellant, accused appellant, Biren Das alias so and so A1, who has also submitted a synopsis of written submission, has submitted, has contended that there was no eyewitness to the occurrence. Full stop. And there was no evidence to the fact that the A1 had any previous enmity with the deceased. Full stop. He has referred to the testimony of PW, prosecution witness, PW 12, who was the wife of the deceased to press such point. Procedural. He has contended that from the materials on record, it has been established that the discovery of the dead body, dead body of the disease was found at around 10:30 a.m. on 21/11/2016. Whereas A1 was arrested only at around 6 p.m. on 21/11/2016. The prosecution cannot base its case on the fact of discovery of the dead body. And cannot take the shelter of under Section 27 of the Evidence Act. For the fact that from the FIR itself, it is evidently clear that the fact that the dead body was dumped in a septic tank was disclosed to the informant by Umesh Dekaetri on at around 4:30 p.m. on 20/11/2016. He has further contended that when A1 was taken by the police personnel to the place at Bonsibosti on 21/11/2016. He was handcuffed and the so-called extrajudicial confession attributed to A1 by the prosecution was not admissible in law. Mr. Tiwari has further contended that the alleged weapon of assault was not recovered on 21/11/2016 as shown in the seizure list, but the same was seized only on 23/11/2016. Where from you are saying, Mr. Tiwari, that 23/11/2016?
My lord, the seizure list, my lord.
Okay. Okay.
'93, my lord.
There was ambiguity in the prosecution case as regards the date of occurrence. He has further contended that the extrajudicial confession of A1 was hit by the provisions of section 24 and 25 of the Evidence Act. The alleged weapon of assault was not sent for forensic and serological examination. The alleged weapon of assault, which had no blood stains on it, was not sent for forensic and serological examination. And was neither sent, nor it was shown to the autopsy doctor, PW6. He has contended that the learned trial court had erred in law to take the confessional statement of A2, confessional statements of A2 and A3 as a circumstance to in a chain of circumstances whereas such confessional statements could not have been, such confessional statements should have been, ought to have been excluded from consideration. Post. He has further contended that most the prosecution witnesses who deposed about the recovery of the dead body from the septic tank are only post-occurrence witnesses, and their evidence did not add any weight to the case of the prosecution. Yes, Mr. Your submission. Only
Insofar-
few points he has already
Yes,
submitted.
yes. Insofar as the submission of my learned friend goes, my lords, first of all, I'd like to adopt those submissions. And in the alternative, my lords, now, my lords, if my lord peruses the judgment, I would say, my lords, the judgment itself is perverse, my lords, to the point where my client, my lords, the
Where is the finding against you?
Yes, my lords, I'll directly come to that. My lords may first come to the circumstances, my lord, which is there in the judgment. It starts from paragraph 53, page 82, my lords.
I have seen.
My lords may come to Roman 2. So these are the circumstances which the honorable judge, learned judge had. My lords, 2, I'll just read it, my lords. Before committing the crime, the quarrel broke out between the deceased and the accused Birendas on the question of money. So,
Mr. Mohanto,
my lord.
learned amicus curiae, appearing for the accused appellant, Bapon Dotto, has, while adopting the submissions of Mr. Tiwari, has further submitted that further submitted, pointing towards the circumstances relied on by the trial court, that despite no clear evidence, the learned trial court had erred to reach a conclusion that immediately before the occurrence, all the accused persons and the deceased were sleeping together in the same room, and before committing the crime, a quarrel broke out between A1 and the deceased.
Yes.
Full stop. In a sense, the learned trial court had invoked the last seen together theory in the case in hand. Full stop. He has further submitted that on 21/11/2016, it was only A1 who was taken by the police personnel to recover the dead body of the deceased at Munshi Bosti, as A2, as the accused appellant Bapon Dotto A2 was arrested only on 22/11/2016. Full stop. How you have been roped in?
My lords, by
Which part?
paragraph 59, 60, and 62, my lords. Now, my lords, I'll just point out
One by one.
my lords.
Which one?
Para 59 page, my lords. There are 3 reasons, my lords. First, 87.
59.
Para 59, page 89 of the judgment, of the paper book. May I read, my lords? 59 is the first reason, my lords. After taking note of the above discussion, it is found,
1 minute.
my lords, sorry, my lords. No resistance was given by the
One. Print out decision.
Yes.
what আছে না মোটার আছে না এবার পাহরিল ওকে 59
Para 59. After taking note of the above discussion, it is found crystal clear that the prosecution has succeeded to establish the guilt of the accused with reliable circumstantial evidence coupled with confessional statement of accused Bapon Dotto as stated above, that both the accused were present at the time of occurrence, though the fatal blow was given by accused Birendas and no resistance was given by accused Bapon Dotto to save the life of the deceased Gorango Das. After giving fatal blow, the accused took part to conceal the dead body with the septic tank with their intention to disappear the evidence of the crime from screening themselves from legal punishment. Now, my lords, for convicting Bapon Das, the learned judge has stated that there was no resistance. But if my lord, the learned judge below, my lords, he had relied upon the extrajudicial confession of the accused A1, the confession of the accused A2, and the circumstances. Everywhere, my lord, if my lord goes through those confession, it was stated that Bapon Das was sleeping at that point of time. And only when the crime was committed purportedly, my lords, only thereafter Bapon Das saw that he was, A1 had the crowbar in his hand and there was blood on the body of the deceased. So the fact, my lords, that he did not resist is, in my humble submission, is perverse, my lords. Because going by the confessions, my lords, it would appear, and the statements of the PWs, my lords, that at that point, Bapon Das was sleeping, my lords, and Umesh was also sleeping. A2 and A3 were sleeping. So this is the first reason why I have been convicted under 302. The second reason, my lord, would find at paragraph 60.
Learned trial court had gone behind the confessional statement of A2 to treat, to hold the accused appellant A2 guilty for both the offenses under section 302 IPC and section 201 IPC in aid of section 34 IPC without examining the admissibility or otherwise of the confessional statement purportedly recorded under section 164 IPC from the standpoint of section 30 Evidence Act. Full stop. It is his contention that before basing its finding on such confessional statement, the inculpatory part and the exculpatory part of such confessional statement are to be examined, and thereafter the learned trial court, only thereafter the learned trial court would have attributed the particular act on the part of the accused appellant A2.
My lord, the second reason, my lord would find it at paragraph 61. The first is that Bapon did not resist. My lord would test whether these reasons are enough to rope in section 34. That is my submission. 61 for a moment, my lord, kindly. Paragraph 61. The second reason why.
Also, in any view of the matter, the confessional statement was clear that the accused appellant A2 had no role in connection with the alleged homicidal death of the deceased. Full stop. Okay.
What two more reasons, my lord?
What?
The second reason, what the learned judge has stated, my lord would find it at paragraph 61. First is that I did not resist. Second, paragraph 61, my lords. For the reasons stated above, my considered opinion is the facts and circumstances of the case points out that fatal injuries were caused by accused Biren in the presence of Bapan Doctor. So second is that I was present when the injuries were caused, my lords. And the third reason, my lords, paragraph 62. So both the accused are deserves to be held guilty for committing offense under 302-201 read with 34 as both the accused were staying in the same room. So this is the third reason. Now, my lords, in my humble submission, my lords, to attract section 34.
Making a statement inculpatory, exculpatory to yourself,
My lords,
inculpatory to others,
yes, yes,
is not of any otherwise benefit.
yes,
Everybody can make.
yes,
Everybody can make such statement. Yes, I am very innocent.
Yes.
All these persons,
yes, yes.
right? This itself is a doubtful one.
I'm not even saying I'm innocent, my lord.
No,
Insofar
that
as
is why I have recorded whatever is required to be recorded.
my lord. Insofar as 201 is concerned, maybe I'm
If
involved.
we
my
go
lord.
deeper
Yes.
into your statement, then you will be more into trouble.
Tomorrow, my lord, I'll place
Hard-
judgment on 34. my lord.
Miss B. Bhuiya. Let additional public prosecutor appearing for the state has submitted that the discovery of the dead body of the deceased was made on the basis of the statement of the accused person, Biren, Dekabira A1, and the said statement has been duly exhibited as EXT 6. Full stop. Thus, the fact of discovery of the dead body of the deceased from a septic tank situated at Munsibari and the Paneri police station is admissible under section 27 of the Evidence Act. Full stop. MS Bhuiya has further contended that on 21/11/2016, though there were some discrepancy in the prosecution witnesses as regards the date of recovery of the dead body, the accused person Biren Das Bira A1 had, in presence of the prosecution witnesses, had pointed out the place from which the recovery of the dead body was made, and such evidence is also admissible under section 8 of the Evidence Act. Full stop. From the evidence on record, it has also emerged that the 3 accused persons and the deceased were engaged in the construction work, as mentioned by the informant PW1 at Munsibari, Kalikhola, Uttor Kalikhola, at the relevant time, and they were staying together at one place. Full stop. From the confessional statement of the accused person Bapon Datta. It has emerged that there was a quarrel. There was a bone of contention as regards what? Payment.
Payment of some money, my lord.
Payment of money between the disease and the A1. And as such, the prosecution has been able to bring on record the motive behind the murder. And the same is an additional link in the chain. Full stop. Anything more?
Lordship, the 34, how they could be roped in, because they are vicariously liable.
MS Learned State Council has heard contended that the Learned Trial Court had rightly invoked the provision of rightly invoked section 34 IPC as all the accused persons had committed the act of murder in furtherance of their common intention. Full stop. It has been contended thus the prosecution has been able to bring proof all the circumstances by reliable evidence, and since the chain of circumstances is complete and there was no missing link, and the judgment and order of conviction and sentence does not and needs no interference. Full stop.
Lordship, section 106.
Huh?
Section 106.
106. How?
Lordship, it should be, it is within the knowledge of the accused appellant, then an explanation.
It needs no interference. So here say no complete record. Further, it is a case where the provision of section 106 Evidence Act is applicable and the accused persons owed an explanation as regards the disappearance, as regards the death of the deceased and concealment of the dead body in a septic tank. We have given due consideration to the submissions of the Learned Counsel for the parties, and I have also perused the evidence materials on record, including the testimonies of the prosecution witnesses and the documentary evidence laid before the trial court, as available in the case records of sessions case number. So it's full stop. We have also gone through the decisions referred to by the Learned Counsel for the parties in support of their submissions.
Judgments, I'll just mark the judgments and place it on 34, applicability of 34.
We are not completing.
Oh, my lord, I'm so sorry. PW1,
Ajoy Deka, who was the informant, knew the deceased and all the three accused persons as they were working under him in the contract he was executing under the Public Health Engineering Department, full stop. Stating that he was the informant in the case, PW1 deposed. After identifying the accused persons, all the three accused persons in the doc, deposed to the effect that on 2011-2016, the accused Umesh Deka A3 came to him and informed him that the accused person Biren Das A1 killed Gorango Das and kept the dead body of Gorango Das in a septic tank at Munsibosti. As the accused Umesh Deka A3 was under influence of alcohol when he disclosed to him, he within bracket PW1 asked his staff to ask the accused Umesh Deka A1 again. PW1 further stated that when his staff confirmed about the incident from the accused Umesh Deka A1, he A1 was taken to Paneri police station by him and his staff. The other accused, Biren Das A1 was apprehended by his staff from a place near Tongla railway station, and he A1 was also handed over to police. P1 exhibited the FIR as EXT1 and his signature therein as EXT11. During cross-examination, PW1 disclosed that he had no personal knowledge about the occurrence and the accused, Umesh Deka A3 could not say about the date when, could not say about the exact date when the occurrence took place. PW1 denied the suggestion that the accused persons were not involved in the occurrence. Next will be. Partly here. Get on to any zakat noise. I think next to I will do. I think this will be seen to clear. Next we have PW15. Part two. Reading a confession as a Supreme Court.
Lordship found one, Lordship
Right.
2003
Otherwise, say Supreme Court Air, Supreme Court 57, page 216. When on reading the confession as a whole, it appears that he was really trying to throw the main blame on the other accused and make out that he was an unwilling spectator, like of the crime committed by the other accused. The utmost that can be stated is that the confession cannot be used at all against the other accused. See to that.
And any 57 my
Ali, did you? 57 to
SC
16.
216.
SC.
Yes.
There is another one. Huh?
2003 10 SCC.
Let us see.
There are 9, 10.
There are 9. If he implicates himself in exactly in the same manner as the other accused, it is admissible.
Right.
Now, here is a case where there are two offenses. One offense, he said, I was reluctantly made to participate to damn the body. But so far the other party is concerned, he tried to,
Dissuade himself. Like
he was not involved in the act of death of the disease. Now the question is whether the whole part will go or only that part
regarding concealing.
only that part regarding 302 will go, but the other part will remain.
Lordship.
That is what
My lord.
we need
My
to
lord.
understand. Have you got it?
My lord.
But this is the two.
If,
Or entirely go.
if it
302 part against A1,
My lord.
it will not stand.
Lordship 34, because they were inside the same room.
No. So far as this confessional statement is
Yes.
concerned, when he tried to put the inculpatory part of murder to A1 and he want to extricate out of it
My lord.
and say that I was only involved in 201.
Lordship.
Right. The point is whether the entire confessional statement will go or some part of it will remain and some part of it will go. That is the question. And that's if entire thing goes, there will be nothing against A2.
No, then still I'll rely on the other circumstances.
Okay, we'll rely. But the main part goes.
Confession part may go.
Main part goes.
Lordship, then the other
And that
circumstances.
A3 statement
If your lordship still
that has no
considers-
value,
My lord,
then other three circumstances we will see.
Fine.
We will see.
because if your lordship
So
considers.
27 is also not
part-
applicable.
Yes. Procedural formalities were not done.
Gone. if it is cart before the horse, go, then we'll see the other part, other evidence. But these are the main points.
Because if your lordship considers a confession statement,
Concentrate on
they are regarding their
section,
presence. I mean to emphasize on the presence part.
concentrate on section 8.
8, yes.
এইখিনি ভালকে থব। Tomorrow?
Or Wednesday.
Tomorrow.
Your lordship have recorded everything.
No, I'll forget everything. Yes, tomorrow. If still now we are not unlock the key, lock, then we'll postpone. এইকেইটা তোমাৰ তাত আছে নে? Madras, মোটাত সোমালো নেকি? বলবীৰ এইটো লোৱা। তাৰপিছত জছপালটো দিছিল নে ইয়াত বলবীৰটো আছে নাই? বলবীৰ এইটো। এক মিনিট। Siprang is not leading to discovery. Huh? In 161, he said that I don't know where it was thrown.
I don't know how relevant is 161, but in 161, Breeden clearly said that
I see. Yes, madam, you're appealing for High Court.
High Court, madam, 1, 3, and 4.
Okay. Earlier, Mr. Mukpartin.
Yes, there's another connected of the same arising out of the same selection process. There's a writ petition.
No, we are taking up this Itanagar bench.
Item 1.
There is another item 1.
I'm very sorry.
Lordship, I'm appearing for respondent number 2 and 3.
State government.
Yes, your lordship.
Yes.
I need some time to file affidavit, your lordship, in this case.
And where is Mr. M. Partin? Senior counsel?
He's appearing for Guwahati High Court, your lordship.
Who is the counsel for the petitioner? নাই নেকি কোনো? ৰাতিপুৱা খবৰ লৈছিল কিবা? কোন আছিল ইয়াতে? ইউ পাঠক। ইয়াৰ বৰভূঞা। ইয়াতেতো এজন ইয়াতে ফিজিকেলি এপিয়াৰ হোৱা আছিল ন? হা? Physically, Mr. A.R. Gogoi. কোনে A.R. বৰভূঞা লিখি দিছে? Okay. কিবা ডিফিকাল্টি হৈছে নেকি? এই লিংক চিংকবোৰ সব ঠিকে আছে নে? কোনখন নাই? The court proceedings of the case pertaining to the Itanagar bench is contracted through remote video conferencing. Full stop. None has appeared for the petitioners and the respondent number 1. Full stop. MS
R. Basar, your lordship.
R. Basari.
R. Basar.
Basar.
Yes, your lordship.
Basar. Learned senior government
Government
advocate.
advocate. No, government advocate, your lordship.
Learned government advocate. Arunachal Pradesh. For the respondent number 2 and 3,
Yes.
who has appeared through virtual mode, has submitted that instructions are yet to be received.
Yes, Your Lordship.
Instructions to file counter affidavit on behalf of the respondent number 2 and 3 are yet to be received and has sought for
3 weeks' time, Your Lordship.
3 weeks further time to file the counter affidavit on behalf of the said respondents. Full stop. As the learned counsel for the respondent number petitioner and the respondent number 1 are not present today, and time has been sought for the respondent number 2 and 3 for filing counter affidavit, list the case after 3 weeks. Is the case 3 weeks of which are the actual to own actual.
$13,900.
39 is okay?
Okay, Your Lordship.
39. 2024.
Oblige, Your Lordship.
Item number 1 for motion.
Yes, madam.
There's a connected matter arising out of the same selection that is due to come up on the 28th of this month.
Yes, Lordship has already issued notice. Yeah.
Notice has been issued in
But
that.
the only difference is that in that case, they have contended that if your Lordship just page number 26 for a moment.
Do you have the order?
Yes, Lordship. In that case, their contention is that Lordship, this notice dated 23/4/2024 is a list of qualified candidates. In my respectful submission, Lordship, this is not a list of qualified candidates.
Which one?
At page 26. This is the list of candidates who have secured marks. And this, Lordship, nowhere says that this is qualifying in nature. This page 26. So those candidates who have appeared in the written examination, they were given marks, and accordingly they were called for in the viva voce, Lordship.
Same advertisement.
Lordship, same advertisement.
Hmm?
And this petitioner
One. Where is the advertisement?
at
Okay,
page
same.
22, Lordship.
You are contesting for which post? SC
Lordship,
or ST?
ST Hills.
Same as the earlier one.
He was contesting for scheduled caste post, Lordship.
Okay. Your name?
Lordship, it appears that if your Lordship
No.
Apna-
Arbora.
Arbora, Lordship.
Okay. Heard Mr. Arbora, learned counsel for the petitioner, and MS S. Sharma.
Respondents 1, 3, and 4, madam.
Learned standing counsel GHC for the respondent number 1,
3 and 4.
3, and 4. Full stop, para. The petitioner has preferred the instant writ petition to challenge the selection and appointment of the respondent number 5 pursuant to a selection process initiated by an advertisement dated 14/8/2023 within bracket annex C. Full stop. By the advertisement dated 14/8/2023, the office of the respondent number 3 invited applications for filling up of 2 vacancies. Yeah, go to side level within bracket SC equal to 1 and plus STH equal to 1 bracket close in the post of office peon. Post of. As per the advertisement, the selection process was to comprise of a common written test for 50 marks and viva voce stroke interview for 20 marks. Full stop. In response to the advertisement, The petitioner submitted his candidature and finding his application complete in all respects, comma, he was issued an admit card,
At page 25, Lordship. Admit card.
Annex D, bracket, to appear in the written test on 25/2/2024. First of, after completion of the written test, comma, the office of the respondent number 3 published a list of qualified candidates.
Lordship,
Ah.
this, Lordship,
Published a list of what?
candidates who have secured marks in the written test.
Okay, published a list of candidates who have obtained the requisite marks
Lordship.
in the written test. Requisite marks out of 50 marks.
Out of 50.
Earmark for written test. And who are qualified to appear in a vivacy stroke interview. That is Annexa E. Annexa E. First of, in the said list of candidates for the post reserved for ST category, comma, the name of the petitioner figured as serial number
8, Lordship. 8. Page number 33.
33.
page number 33.
Serial number 8, roll number 38. Lordship.
No. In the written test.
29, Lordship. Page number 29.
Ah,
Serial number 5. Roll number 38.
oh. Serial number 5,
Roll number 38. B.
29.
Lordship, 32. He has secured, obtained 32.
No.
Page
Page
29.
29. yes.
29.
Page 29.
Okay.
Serial number 5.
No, you are saying you are SC,
No, I'm saying I'm ST Hills. The,
you are ST.
yes.
Okay. In the list of candidates published for the post reserved for STH category. So you are similarly like
No,
the other petition.
No, that petitioner belongs to SC category.
I put it wrongly.
Lordship had,
Question is the same.
yes.
The
In fact,
question
Lordship
is
declared
the
it
same,
rightly.
my lord.
No. You are ST or SC.
ST Hills.
STP.
The other candidate, what was his name?
Name
Bailung. He was also STH.
Yes.
Kullanjiti Shambhu.
Why you are saying that he is not? In the order itself, I think Bailung is STH.
It's STH. STH.
Yes.
Same, you are competing with the same petitioner,
Yes,
the
yes,
other
yes,
petitioner also.
Yes.
While competing with, who was the respondent of 5 there?
He is also STH. Bison Singnar.
Same man.
Same.
Same person.
Same.
Not same.
Huh?
No, not
He has also been added as a respondent number 5 in the earlier repetition.
Yes, same person.
Yes,
Respondent
same
number five,
person.
denied
Yes.
respondent.
Why you are
Yes.
confusing
same
the court?
Right.
Same person,
Yes.
is it not?
Yes.
Then why he was saying that he is
I thought
SC?
that your lordship has asked me regarding the petitioner who had first filed the writ petition.
He was also ST.
Yes.
Yes.
So I'm not actually challenging that person's. So I
No,
thought.
after
yes.
suppose respondent number 5 goes,
Yes.
then you will be competing with the other petitioner.
Yes.
Likho kenege. In the list of candidates for the post reserved for ST within bracket H category, comma, the name of the petitioner figured at serial number 5. As he obtained 32 marks out of 50 marks.
50 marks.
There that other petition is at serial number 1.
Yes, Lordship.
So the name of the respondent number 5 also figured in the said list of candidates as serial number 17 with 12 marks. After the viva stroke interview, held on 36/2024
24.
interviews were over. The respondent number 3 published a list of compiled marks. Annexer F. Obtained by the candidates in the viva stroke interview held on 36/2024. In the state list of compiled marks, the petitioner was shown to have obtained
Serial number 8, Lordship, page number 33. Yes, Lordship. Serial number 22 is the respondent number 5.
marks, obtained total marks of 51. And the respondent number 5 was shown to have obtained 56 marks. 56 marks.
Yes.
Huh?
Yes, 56 marks.
একটু ভুল হয়েছে প্রস্তাব Pursuant thereto, the respondent number 3 published the select list of candidates for both the post of SC category and STH category on 1/7/2024, showing the respondent number 5 as the one selected for the post of office peon under STH category. 1/7/2024 within bracket annexer G. Para. Submission is same.
Lordship, here, Lordship, in my respectful submission, Lordship, since the selection process consisted of 2 stages, stage 1 and stage 2. Stage 1 and stage 2, Lordship, if a Lordship peruses the entire advertisement, the stage 1 nowhere says, advertisement nowhere says that stage 1 is only qualifying in nature. Therefore, the marks given in both the stage 1 and stage 2 has to
I
be
think
considered.
same.
Yes,
Same submission.
Yes, question is the same.
yes,
The submission recorded in the earlier order
yes.
and
Same.
your submission is same.
No, in
Why no? He has contended that the marks obtained in the written test and the average of the marks given by the 3 members of the interview board should have been the basis for selection.
but they did not say that this particular list of candidates is qualifying whether
Their
it's
response
qualifying.
is yet to come.
Yes. But Lordship, I am saying that this is not qualifying in nature because of the fact that the person who has secured 7.5 was directed to appear in the viva voce.
Huh?
Yes. At page number 30.
That part I have already
Yes.
recorded in the paragraph number 2. As per the advertisement, the selection process was to comprise of a common written test of 50 marks and viva voce interview for 20 marks. So your case is that the marks obtained in the written test is to be included,
Yes.
right?
Yes.
That is your submission.
Yes.
That is already recorded.
Yes.
If you have gone to the earlier order,
Yes.
Para 3, Mr. Bora likhi dibo. Naam to boy regi. That man has already been appointed.
Yes, well, okay.
Yes.
See,
Para 4, Para 5, 20. MS Para 4 likhi dibo. Pisot, ekhini pisot. Jitu ase already. Yar pisot likhi dibo. Buji paise? Ekhini pisot likhi dibo. MS Sharma has further submitted that another writ petition, WBC number 4004. Oh, sorry.
3732, my lord.
3732 732, 2024, comma, involving similar issue, comma, is pending for consideration. And the next, and the said writ petition is ordered to be listed on 28/8/2008. First of all, para 5. Para 6 should live. Let notice be issued. First of, as it is submitted that the another writ petition WPC number 3732/2024 involving similar issue is ordered to be listed on 28/8/2028, comma, the notice in the instant case is also made returnable on 28/8/2024. Full stop. Para 7. 3 days or 2 days করে দিয়ক বৈরাগীৰ ঠাইত বৰা কৰি দিয়ক 8 to 8. You served Dusty then
Lordship, in respect of 5.
in additionally.
Yes.
Para 8 লিখিব, the petitioner shall take steps for service of notice under response number 5 by registered post with AD within 2 working days from today. তাৰপিছত একেখিনি লিখিব 10টি একেখিনি থাকিব খালি 3 days 2 days কৰি দিব 9 to same 9 to same.
Lordship, the selection and appointment of the respondent number 5 may be subject to outcome of the
Similar order,
Yes.
similar like paragraph 9,
Lordship.
subject to the outcome since he has already joined.
Lordship. All right.
Gupta and Paul
Lordship,
will not.
just one small prayer, Lordship. In the earlier matter, that VC matter relating to Itanagar bench, Lordship, I am appearing on behalf of Mr. A.R. Gogol, Lordship. Can that be read?
আপুনি লৈছিল নেকি চাওঁ আগৰটো গ'ল নেকি
We had served the extra copies, my lord. They are now to file the affidavit.
Today High Court counsel did not appear
Lordship.
from Itanagar bench.
Lordship.
Only the government advocate for respondent number 2 and 3.
Yes, Lordship.
They have sought for 3 weeks time.
Lordship.
So the era লিখি দিয়ক Mr. A. Kapil,
DJ Kapil, Lordship.
DJ Kapil, learned counsel representing Mr. A.R. Gogoi. আগৰ পৰা কোন পঢ়ুৱে লিখি দিছে learned counsel but a petitioner is present. Then খালি 1 to 1 or present নাই.
Highly obliged, Lordship. Thank you.
Date is given already.
Good, Lordship. I've got that.
Paul and Gupta, I don't think. Let us be prudent. Some other day. I don't know, because of the division bench, it is very difficult.
Otherwise that I have prepared the written argument, Lordship,
Give it to the court master.
on the next day. If it is fixed, another day.
Give it so that I
Yes,
can, if I am able to complete, I will dictate.
Yes, ma'am.
Give it. Okay. P. Hazarika. Learned counsel for the petitioners and Mr.
Shi Sharma, Lordship.
Shi Sharma, learned counsel, representing Mr. R.M. Das. Learned standing counsel, Water Resource Department are present. আমার division bench কি আছে যোগাযোগ ঠিক আছে কিবা আজি রে 12 We can make a try on 27.
27.
27.
27.
27. Yes, Mr. Doctor. Pleading is exchanged. Pleading is exchanged.
Exchange.
We can try on some other day, not possible.
Yes, today not possible.
Sitting in a division bench
Yes,
becomes difficult.
absolutely. I have seen personally today. Very difficult. And this criminal appeal is to be, and Lordship has a
also that the everything,
Huh?
each and every words. So that is to be also there.
No, because it is a question
Yes,
of life
course.
imprisonment.
Yes, yes, absolutely, absolutely.
Question of life imprisonment.
Question of death, question of life, absolutely.
And not only one, two.
Yes,
Confessional statement, all these are required to be looked into.
yes, yes.
When? Not 27, that will take some time. This other two, item number 2 and 3, which I have posted on 27, it will take some time.
6th of September, man.
6th
I'll
of-
be here on the 5th of
Okay,
6th of September. Friday.
Okay, 6th of September. B. Dr. Learned Senior Counsel, assisted by Mr. S. Deka, Learned Counsel for the petitioner, and Mr. N.K. Sharma, Learned Counsel representing Mr. H.K. Das, Learned Standing Counsel, GHE,
2, 3, and 4 and 5.
are present. Full stop. Learned Counsel for the parties have submitted that the exchange of pleading is complete. And case B, full stop. List the case on 26/9/2024, comma, as agreed to by the Learned Counsel for the parties, comma, for admission. We'll do
Interim order.
interim order, interim order.
Grateful, man.
Procedural Islam. Yes, Procedural Islam.
In this
You are the
case, well-
petitioner or what?
Petitioner,
You are the petitioner by name or what? Procedural Islam,
yes.
Ar Islam. Yes, what happened?
Madam, the service in respect of response number 5 is awaited.
Awaited. Our Islam, Learned Counsel for the petitioner, Mr. N.K. Sharma, Learned Counsel representing Mr. H.K. Das, Learned Standing Counsel GHE for the response number 2 and 3 are present. Full stop. In view of the office note dated 8/8/2024, comma, await for the service report in respect of the response number 5. List the case on 27.
Yes,
For service report,
yes. Much.